On February 11th of 2023, this defendant forever silenced the voice of Alexavier J. Pedrin, or as you've come to know him through this trial, Alex. On February 11th of 2023, this defendant extinguished Alex through her brutal assault and her intentional drugging. Alex's voice cannot tell you what happened, but Alex's body is screaming out to you that he was abused and he was drugged. You saw the graphic photos displayed of Alex at autopsy. You saw the bruising on his body, on multiple planes on both sides of his face and head, and throughout all sides of his scalp, including on the top of his head. That was this defendant's stamp of abuse. You heard the levels of Xanax inside of his body. That was so this defendant could quiet his cries. Alex suffered in his final hours as he bled internally from inside of his abdomen. The Xanax slowed his respiratory system. Every breath that he took was pained by that rib fracture he had. With less blood to deliver oxygen throughout his body, his brain swelled and his body began to shut down until Alex took his last breath. At 9:44 a.m. on February 11th of 2023, Alexavier J. Pedrin was declared deceased. If Alex were alive today, he would be 9 years, 10 months, and 4 days old. He would be finishing the 4th grade. Alex is missed by brothers and sisters. Alex's death has left a hole in the heart of his mother, Jenna Love, and his father, Derek Pedrin. Through this defendant's abuse and intentional drugging, this community, your community, has forever lost the potential of Alex's life and what it could have been. Alex mattered. This trial process is about protecting the defendant's constitutional rights and proving that this defendant is responsible for Alex's abuse, Alex's neglect, and his death. At 9:25 a.m. on February 11th of 2023, this defendant called 911. You know it because you heard it. According to that call, she woke up to find Alex on the ground. Twice during that call, she represents that Alex's body was on the ground. She says that Alex was unresponsive and that there was an open bag of her medication on the floor. The defendant reported that she tried CPR on Alex's body to no avail, and that Alex was not breathing. As that 911 call is taking place, deputies Jar and Anderson arrive on scene. It's perhaps one of the fastest responses one could see to a 911 call. The person is still on the call, and the deputies are arriving on scene. When they arrive and this defendant opens the front door, Alex's body is on the bed, not the floor. There is a white sheet under his body to protect the bed from any accidents during the previous evening. That white sheet is undisturbed. It tells you that after Alex was put on that white sheet and in that bed, he did not move to the floor again. It's where he died. Alex's body was in rigor. His left hand was tucked inside of his pants, and his right hand was up towards his head. The left hand being tucked into his pants tells you that his body was not moved from the floor to the bed. As Deputy Jar touched Alex's body and rotated it onto its side, you saw the black substance start to leak out of the side of his mouth. That small movement of just rotating his body to one side caused that substance to start coming out of his mouth. That tells you that this defendant never performed CPR. It was a lie. This defendant told Sergeant Williams that she performed CPR for upwards of 10 minutes. You observed Deputy Jar actually perform CPR and what happened when he just started to perform CPR. You saw the substance start to ooze out from Alex's mouth. And then as the body was moved to the floor, how it continued to ooze out and pool behind his head. That tells you there was no CPR before Deputy Jar arrived on scene. This defendant also said, when she was on the stand, that after trying to perform CPR, she held Alex's body in her arms and cried. You saw the simple movement of moving his body to the side. The simple movement of holding his body in her arms would have caused that same reaction. This defendant didn't hold Alex's body. This defendant didn't cry. You saw her face when the door was opened. Through the investigation into this case, you know that this defendant texted Laura Lee Raines at 9:07 a.m. According to the defendant, she did not immediately notice Alex was not on the bed. You know from the forensic interviews of both Araya and Brantley that they slept upstairs. You know from the testimony of Brantley that he verified once again that he slept upstairs. There were only 2 people in the bed on the evening of February 10th, 2023. This defendant and Alex. And as soon as this defendant woke up, if what this defendant was reporting was true, she would have known immediately that Alex's body was not in that bed. But Alex's body was in that bed. It just wasn't moving. Because he was dead. The children tell you that's what happened. The scene investigation tells you that's what happened. Alex's body tells you that's what happened. Your common sense tells you that is what happened in this case. At 9:20 in the morning, this defendant texts Rafael Suarez. "Something is wrong with my son. Don't come." The text message to Rafael Suarez, the person that she's supposed to go on a date with, goes out before she calls her own mother about Alex. The text message about Rafael Suarez saying don't come over regarding her date goes out before she calls 911. At 9:21 a.m., the defendant calls her mother, not 911. For 52 seconds, they talk. And then over 3 minutes pass after that phone call to her mother, where the testimony establishes that the defendant's mother instructed her to call 911. 3 minutes plus pass until at 9:25 and 52 seconds, she calls 911. There's only one person in the whole world who could have drugged Alex. That person's in the room, and she's seated at that table. Common sense tells you that medication that you take anytime takes effect within an hour or two. The amount of Xanax in Alex's system, you heard through the defense expert witness, was enough to potentially cause the death of an adult. That tells you about the amount of Xanax in a 6-year-old child's system. This isn't candy. This isn't something that you munch on. This is bitter pills. And they're inside of a 6-year-old child's body. It is impossible for Derek to have drugged Alex. Because if Derek did it, he left the house at 7:15 when he was arrested. If he drugged Alex, Alex would have been feeling the effects of Xanax by 8 to 9 o'clock. He would have been unconscious by 9 to 10 o'clock, dead by 11 to midnight at the latest. It is impossible. You know that Alex was awake until 3 a.m. That's what the defendant said repeatedly and did not deny when she took the stand. You know that she tried to put Alex to sleep around midnight, and he was still awake to the point that she turned the TV back on, and she continued to text Rafael Suarez. You know that Alex was actually awake because Laura Lee Raines heard over the phone Alex's voice saying what he wanted to do that evening. Alex was awake. Alex was alive. He was well. There's only one person in the whole world who could have staged the scene knowing that Alex had drugs in his system. That person is in this room, and it is the defendant. This defendant told you that she believes the bag that had the medication was up high. That was her testimony just yesterday. Her belief is that that bag was in a place where only adults could reach it. Derek was in jail that night. The only person that had the opportunity and the ability to take that bag and stage that scene is this defendant. This defendant knows what's inside of that bag because it's her medication. She's the only person that had both the opportunity and the ability to stage that scene. Both forensic pathologists that testified in this case agreed that Alex had Xanax in his system after he was beaten. Alex was brutally beaten first, and after he was brutally beaten, that's when the Xanax was in his system. After Alex is brutally beaten, you know that he already has a fractured leg and limited mobility. The beating left him with a broken rib that brought pain to him with every breath. You know that he had abdominal pain with a laceration to his liver and bleeding into the mesentery cavity. You know that that pain would increase over time. You know that he had multiple blows to his head and to his body. For Alex, movement would have meant more pain. And he couldn't even access a bag that was at a height that only adults could grab it. Only this defendant could have done that. The person who administered that drug to Alex would have to know that he was beaten. He would have to know and want to silence him after he was beaten. And they would have the ability and be the only person that had the ability to stage the scene, to put the bag out, to dump the pills inside of the bag, and put the empty canister of the prednisone by Alex's body. The scene investigation conducted by law enforcement verifies that the scene was staged. Every bottle inside that bag had the child safety locks engaged. The pills inside of every single one of those bottles inside the bag matched. The pill bottle outside of the bag had pills inside the bag that matched the prescription. 10 of 12 dumped on the inside of the bag. For you to believe that after Alex was brutally beaten, he would grab and access this bag and then find medication in that bag, you would have to believe that he would A, be able to open the bag and unzip it after being beaten, B, engage the child safety lock, C, empty out all the pills in the bag except for the pills that were Xanax, and somehow magically ingest only the Xanax, and Xanax at a level that would kill an adult potentially. Those are the facts that the defense is trying to sell you, and ladies and gentlemen, do not buy it. The scene investigation in this case also tells you so much more. Alex's pants are stained with cotton candy. There's an empty cotton candy container on the floor. There's also, if you look close enough, an empty can of Red Bull. And you know from the autopsy results that Alex had caffeine in his system. You know that it was a problem for this defendant that Alex would get up in the middle of the night. That's a problem that this defendant created. But Alex would get up in the middle of the night. And like any 6-year-old child, he sought sugar, he sought Red Bull, he sought the things that taste good. And so his pants are stained with cotton candy. The testimony of Investigative Sergeant Amundsen established that there was cotton candy particles throughout the bedroom. It stained the carpet, it was on the wood. The pieces that he had collected from the bed, he originally sees and then he picks up and he says, "This looks like cotton candy. It looks like what I'm seeing everywhere else."
Overruled. Keep on going.
You know from phone analysis that this defendant was texting Rafael Suarez during the evening of February 10th into the morning of February 11th over 160 times. Those text messages actually start at 6:18 p.m. while Derek is still at the residence. Derek arrives home from work sometime after 5:30 in the evening, and she is texting another man. And that's her right. You know that the relationship between Derek and this defendant is toxic to say the least. But those text messages establish a number of things. That she's awake till just before 2 a.m., the last time she sends a message, and then after 2 a.m., when she's not texting Rafael Suarez, she and Alex are left awake and alone. This defendant beat Alex. The beating was a brutal beating. You saw the bruising on his body. During the welfare check conducted by Deputy Kerneen, he observed Alex, not once, but twice. He came into the residence and he saw one old injury above his eye and one bruise on the back of his leg. Deputy Kernine also told you what Alex was wearing. The only thing that Alex was wearing at that time, when he looked a second time, was a pull-up diaper. The other thing that Deputy Kernine told you is that between the two times when he saw Alex in the residence, Alex repositioned his body. He moved his body on the couch. No other bruising, no redness, no signs of tears or recent crying. And in this defendant's own words, Alex was asleep. In this defendant's own words, the next morning, to Sergeant Williams, Alex was asleep from 5 p.m. to 7:30 to 8 p.m., the entire time that Derek was home. That's consistent with what Derek told you when he took the stand. Derek said when he came home that there was a bucket of throw-up that he took and cleaned up. And then he was cleaning up around the house. Both of those facts were verified by Deputy Kernine. Because when Deputy Kernine comes over after conducting the welfare check, the bucket next to Alexavier is empty. The throw-up has been cleaned up. But when Deputy Kernine arrives at the residence and he's looking in the windows, and Derek has no idea that law enforcement is there, Deputy Kernine testified and told all of you Derek was sweeping and cleaning the kitchen, which is exactly what Derek said he was doing. Here, the defendant's own words seal her fate. You saw the text message at 9:06 p.m. that this defendant sent to Rafael Suarez. She said, "I just showered." That text message is in response to a message from Mr. Suarez asking, "What are you doing?" From 7:47 p.m. through 8:29 p.m., there is no activity on the defendant's cell phone. From 7:47 p.m. to 8:29 p.m., her phone with no activity is consistent with a person showering. What's more, the photograph that you saw this morning, the selfie, the first selfie that she took, is consistent with someone who got out of the shower within a half hour. Her hair still looks wet. She's got a bathrobe on. She has no makeup on her face. And then within 20 minutes, she has makeup on, her glasses on, but the same bathrobe on. She was improving her appearance because she was having an ongoing conversation with Mr. Suarez. But make no mistake about it, she showered. Why is that shower important? Because this defendant told you when she took the stand yesterday that she would never shower with dirty underwear and a bottle that was used for urine in the bathtub. The defendant wants you to believe that Derek came home, became angry at Alex for using the bathroom in his pants, took him into the bathroom, and brutally assaulted him. And she says the proof of that is the dirty underwear and the bottle that was in the tub. The dirty underwear and the bottle that were in the tub couldn't have been there when she showered. They came after the fact. It came after the fact because they were photographed the next morning. The defendant's story that Derek beat Alex in that bathroom is just that. It's a story. She's attempting to escape responsibility from her actions, something that you know she does from Dr. Endres. And this defendant herself changes the story. She went from showering earlier to not showering. Think about all the children that were home when this defendant says that that beating took place. Major is in the room right next door. He's been interviewed multiple times. He would have heard that brutal beating because this defendant reports that she heard it from upstairs. Brantley is home on that same floor. Araya is home. The defendant's story is not supported by Deputy Kerneen's observations. It's not supported by what this defendant originally reported to law enforcement, which is that Alex was asleep that entire time, which is completely supported by Deputy Kerneen's observations, which is completely supported by what Derek told all of you, which is completely supported by the scene with the garbage can being emptied and Derek sweeping. You also know it didn't happen because Laura Lee heard Alex's voice on that phone call at 10:30 in the evening. You also know it didn't happen because this defendant reported that Alex was fine that evening. Multiple times she told law enforcement. At the end of performing CPR, when Deputy Anderson tells the defendant that Alex is gone, the defendant's response is, how is that possible? He was fine. After being in this trial for the last 2.5 weeks, it's really easy to want to blame Derek Pedrin. You know that Derek Pedrin is violent with women. He is. You saw disturbing and disgusting conduct on multiple videos that involved Derek. At the beginning of this trial, during my opening statement, I told all of you, Derek is a domestic abuser, and by God, he is. Large portions of this trial actually felt like this trial was a domestic violence trial and Derek Pedrin was on trial. Perhaps one of the benefits of this trial be that Derek Pedrin was faced with his domestic violence in those videos and his conduct. Will it change his behavior? Who knows, but one can hope. But don't fall for this defendant's smokescreen. Do not let her use his domestic violence against her to allow her to get away with a homicide of a child. You were told during opening statements by the defense that there were going to be multiple witnesses, one of which was going to come in here and tell you that they witnessed Alexavier get struck and beat more than 12 times. That didn't happen.
Judge, completely improper objection.
Go on to, what? No, overruled. Go ahead.
You heard you're going to see multiple videos of the same. There's one video that's been admitted where Derek Pedrin is yelling horrible things at Alex inside that van. Things that are abusive. There's another video from years ago where the children are tapping their heads and they say, "Dad just hit me." Those are the two videos you saw that are supposed to establish that Derek is a child abuser. Context also matters. Deputy Paff, during his testimony, talked about a prior domestic violence offense that he responded to the residents just a week or so before. He talked about Alex and Derek's interaction during that time. In fact, it came up again because on the evening of February 10th, Derek said, "Can I say goodbye to my kids?" And the deputies say, "You remember how it went last time. We can't do it again for that reason." Days before, they could not pull Alex off of his father. They could not pull Alex off of Derek. And it created a situation for almost 20 minutes where law enforcement had to work to separate them. That encounter tells you what you need to know about Alex's relationship and love for his father. Make no mistake about it, Derek has responsibility. He has responsibility for Alex's neglect. He has responsibility for not getting Alex to the doctor on time. He has responsibility for not ensuring that Alex was attending school. He has responsibility for bringing drugs into the home for this defendant to use. But Derek's responsibility is not for you to decide today. You are deciding this defendant's responsibility. And his responsibility cannot be an excuse for this defendant to avoid responsibility for her actions. You have heard even more compelling evidence that this defendant is responsible for Alex's abuse and his death. The defendant's own children. In a forensic interview that was conducted by Major, and remember the dynamics of the forensic interview. At the time that law enforcement originally responds on February 11th, they believe this may be an overdose of prednisone. There's bruising on Alexavier's body on the outside, but they don't know about all the trauma on the inside. In an abundance of caution, law enforcement sets up forensic interviews of the children. Major goes and stays with his dad, a dad who has no idea what's happening inside the home of the defendant. Brantley and Araya stay with the defendant's family. They are with separate families and think about what they report in those forensic interviews. Major says that this defendant kicks Alex a lot in his chest and in his face. That this defendant kicked Alex the last time Major saw Alex. That'd be the night before he died. That this defendant has choked Alex on multiple different occasions. That this defendant gets mad at Alex because Alex gets up at night for snacks. This defendant puts hot sauce on his food as a punishment. That this defendant stomps or steps on Alex's chest. Major was interviewed a second time, less than a month later, on March 2nd of 2023. During that forensic interview, Major talked about the purported stairway fall and what this defendant did after that purported fall down the stairs by bending Alex's leg until Alex cried out in pain, and the defendant told Alex to be quiet or she would bend it further. Major also talked about seeing this defendant choke Alex during that same encounter. Brantley was interviewed originally on February 12th. Brantley talked about Alex stealing, that this defendant got mad for the stealing and kicked Alex in the chest, that Alex whined and winced in pain. Brantley made a statement in that forensic interview about how this defendant in the past used a spoon to strike Alex. When he was asked if there's any choking in the house, he said, "Yes, my mom does it, and she does it to Alex." Both Major and Brantley independently say all of this happens when Derek is not home. And Brantley says, the evening before Alex passed, he was asleep upstairs. Brantley made statements in that forensic interview about green poisonous water. He made statements about guns upstairs, diamonds upstairs, and the spoon being upstairs. Those statements have been represented as untrustworthy just because of the nature and the content of what they contain. This is a 5-year-old child talking. Do not judge a statement of a 5-year-old child from the perspective of an adult. I like to take my kids to sporting events. When they're much younger, I would take them to Brewer games. When someone would ask me what happened at that Brewer game, I would talk about the pitching, who hit well, what the final score was, and how the Brewers played overall. The perspective of my daughters, who were much younger, would talk about what they got to eat. Did Dad buy licorice? Did we have ice cream? Did we go to the PlayStation inside the stadium? We had the exact same experience, but the perspectives that we had as an adult and as children were different. Brantley talked about green poisonous water. Remember the scene photographs? There was green water in the toilet. Brantley talked about his dad having guns. How many times in those videos that we are shown were there actual arguments about firearms in that house? It came up more than once. Brantley talked about diamonds being upstairs in that same area. It makes sense that jewelry and a gun or those type of items are all going to be stored in a safe area in the house. That's a 5-year-old child's perspective. That's what he's describing. Remember that. Brantley was interviewed a second time after Derek recorded Brantley. You saw Derek record Brantley. You saw the full recording. Derek actually asked open-ended questions. Tell me what you just said. What happened after that? What happened after that? Those are open-ended questions, the kind that you heard from Danielle on the stand that you should use when you're interviewing a child. Based on those open-ended questions, a second forensic interview is set up of Brantley. During this interview, Brantley said that this defendant pushed Alex down the stairs. But what's important about what he was saying is he's talking about a push down the stairs before death. He's not talking about the push down the stairs that happened resulting in the broken leg. He's talking about something that happened within the time frame right before Alex died, where this defendant was abusive of Alex. He says that Alex would get up at night for food, and he describes how this defendant pushed Alex down the stairs. Brantley says it happened the day before Alex died. Why is that important? Because when Brantley took the stand and talked about that fall, he said the exact same thing when he testified in this courtroom before all of you. That there was a push down the stairs the day before Alexavier died. You know the dynamics of where each one of these children lived in separate households. And you saw both independently testify to the vivid abuse they witnessed at the hands of this defendant. Major took the stand in the very same courtroom where his own mother is in the courtroom. Think about that from the perspective of both Major and Brantley. They came into the courtroom and they testified in the same room as their own mother about what she did to their own brother. Major said that the defendant would punch, hit, kick, and choke Alex. He said all of these things happened while Derek was at work. He described a specific instance of kicking in the kitchen where the defendant kicked Alex while Alex was on the ground, kicked him multiple times. He talked about another incident that happened in the living room where mom, quote, kicked Alex everywhere on his body. He talked about multiple instances of choking, including one that happened the day before Alex died, where the defendant was on top of Alex, straddling him. And he gave a really powerful and a really vivid description of Alex's response, his bodily response to being choked. He talked about how his arms and legs were flailing. Think about that. Think about that, because that is a natural response to someone choking and trying to fight off being choked. And he's telling you with his eyes what he saw this defendant do. He talked about how this defendant would punch Alex, and he demonstrated with his fists. He talked about how Alex would be treated differently with food. He'd be kept from eating. He only got crust from the pizza. He'd get hot sauce on his food. He was treated differently. He was made to sit on the floor if he didn't finish his food on time. Talked about how Alex would get up in the middle of the night. The defendant told you that Alex got up in the middle of the night. Brantley, who has not been living with Major, has been living with Derek, verified Major's account of events. He described this defendant assaulting Alex over and over. Talked about Alex being on the ground and the defendant kicking Alex in his chest. Brantley said this defendant would abuse Alex a lot, that she would routinely choke Alex. Alex's face would turn red and sometimes purple. This defendant would choke, kick, and hit Alex on more than 3 occasions. During this trial, he was asked about food for the first time. He says this defendant would put hot sauce on Alex's food. This defendant would add more hot sauce if Alex wouldn't eat the food with the hot sauce on it. Years passed between those original interviews in February of 2023. Major was now 12 years old when he took the stand. Brantley was 9. They have grown up. Their vocabulary has improved. They have more words to tell you what happened, and they use that vocabulary and those words to tell you what they've witnessed in their home with their own eyes at the hands of this defendant. Ladies and gentlemen, child abuse is a crime that happens behind closed doors. Perpetrators of child abuse rely on that fact. They rely on the fact that the public is shielded from their actions, that you can't see what happens in the home, that the victims of child abuse are people that they have relationships with, that the witnesses of the child in the home are people that they have relationships with. That provides perpetrators of child abuse like this defendant with protection. But this defendant's own children told you about this defendant's abuse of Alex. And if you're wondering why, and the state doesn't have to prove motive, there's a couple things for you to consider. This defendant suffered a traumatic brain injury by Alex's mother, Jenna Love, hitting her with a baseball bat. Alex's father, Derek, has repeatedly abused this defendant. Alex as a child, every time she looks at Alex, is a reminder of Jenna Love and being assaulted and having to take care of Jenna Love's son, and a reminder of Derek's domestic violence and having to take care of Derek's son. And if you still have doubt, and you shouldn't by now, you can consider this defendant's prior conduct and whether it establishes the identity of the person who abused and neglected Alexavier. You know that in 2011, Haley suffered a traumatic brain injury. Haley was admitted to the hospital with multiple skull fractures. According to this defendant, Haley suffered that traumatic brain injury from a fall downstairs. In 2013, Haley was admitted to the hospital yet again after living with this defendant and Dustin Barnes for a period of 6 months. In those preceding months, Haley went from the 80th percentile in weight to the 6th percentile in weight. She was losing hair, she had a fractured foot, and potential fractures in her hands. Haley was not this defendant's child. There was another child the same age as Haley that lived in that house, and the two were treated different. Alex is not this defendant's child. There are children of a similar age to Alex in his home. According to those children, Alex was treated different. You can only use the evidence from 2011 and 2013 if the similarities from that evidence, and in this case, help you identify who the perpetrator of the abuse was. I want to talk a little bit about child neglect. Alex had over 100 absences from school in 2 years. In a little over the half year that he attended the first grade, he had 40 absences in 75 days. The principal of Alex's school testified about the harm that is caused to children when they don't attend school. It impacts their growth, it impacts their development, it impacts their functioning, it impacts their social skills. You also saw Alex's appearance at the time of his autopsy. He was extraordinarily thin. He was dehydrated. Conditions that were consistent with what the children described with terms of him eating or not being able to drink, because if he drank, it would cause him to have to go to the bathroom. You know that Alex had a broken leg. You know that Alex wasn't taken for medical treatment for days after that broken leg. Derek deserves responsibility for that, but so does this defendant. There are many ways in which you can get a child to a medical facility without having to drive them there. There are many actions that this defendant could have sought to try and help Alex. And I want to go back to Alex's death. A person who intentionally administers a drug to a child to put that child to sleep has a responsibility to watch over that child. When you engage in that extraordinarily dangerous conduct, that's not an excuse for you to go to sleep and hope that everything turns out right the next morning so you can go on that date. But that's what this defendant did. Giving Alexavier drugs and then going to bed after he is knocked out and not watching over him contributed to his death. Because if there was action taken, monitoring to counteract the effects of those drugs, Alexavier could still be alive. In this trial, you get to consider this defendant's words and actions. She never disclosed the abuse to the children outside of one arguable 911 call to police, to friends, to family, except for one video that she sent to Laura Lee. And what were her instructions with the video that she sent to Laura Lee? Hold on to it in case I need it. Not help me, not help my children, not protect me or protect my children. Hold on to this in case I need it. You know that this defendant got rid of the SD cards. Special investigator or investigative Sergeant Amundsen saw those SD cards on February 11th, 2023. He didn't collect them that day, and I imagine he's kicking himself for it. This defendant had the password, the ability to log in, and when you log on to the account, it sends a notification to the email of that account. We saw the notification when Investigative Sergeant Amundsen logged in. And as he's logged in, the videos are being deleted. The holder of that account would get the notification and be able to sign in and delete those videos. This defendant was deleting those videos. You know that after the death of Alexavier, Derek was meeting with law enforcement, gave a statement to law enforcement, was cooperating with law enforcement. And this defendant's response to that was to tell him he should not do it. This defendant's words, her actions show her guilt. Her lies about the shower establish her guilt. After I've been speaking to you for a while, I'm now going to talk about the law, the most exciting part. That was supposed to be funny, none of you laughed. Count one is first-degree intentional homicide. It has two elements. The defendant caused the death of Alex, and the defendant caused the death of Alex with the intent to kill. I want to talk about the intent to kill. Intent to kill includes language that the defendant's actions were practically certain to cause the result. You saw the brutal beating that Alexavier sustained at this defendant's hands. You saw the drugging and the amount of drugs in his system. There can be no conclusion, but each of those combined demonstrates that it's practically certain to take Alexavier's life. It is difficult to fathom a caretaker, someone who fills a parent-like role, extinguishing the life of a child. And for that reason, you have lesser included offenses to consider. You have the ability to consider whether or not the defendant's actions were intentional or utterly reckless. Make no mistake about it, it is the state's position that this death was intentional. The beating, the brutal beating, combined with the administration of a drug at that level, made it practically certain that Alexavier was going to die. Count two, child neglect. One of the elements is a person responsible for the welfare of a child. A girlfriend to a parent is a person responsible for the welfare of a child because that parent is using or employing that person as a caretaker for their children. You have to find 3 acts of child neglect during that time frame, and you don't have to even agree on which 3 acts, as long as all of you agree that there were 3 acts of neglect. There's medical neglect, there's educational neglect, there's nutritional neglect in this case, supervisory neglect, and there's multiple forms of each. All you as a jury has to do is find 3 or agree that there were 3, and you don't even have to agree on which 3 constitute the 3. You do have to agree on the one that led to death. For that, the defendant had a responsibility to Alex to watch over him after giving him that drug, and she failed in that responsibility. I've talked about that already. Count 3, repeated acts resulting in death. Again, you have to find 3 acts, and you don't have to agree on all 3. The testimony of Major gives you 3. The testimony of Brantley gives you 3. Alexavier's body gives you more than 3. From that, it's easy to find 3 acts of child abuse that this defendant inflicted on Alexavier. Did the defendant cause bodily harm is the first element for each one of those acts. Bodily harm includes physical pain, injury, or impairment of physical condition. All Alexavier had to have was pain or impairment of his condition from this defendant's acts. That the defendant acted intentionally. Kicking someone is an intentional act. Punching someone is an intentional act. Hitting someone is an intentional act. And by God, choking a 6-year-old child is an intentional act. Did one of those acts cause the death of Alex? This is where you do have to agree. You have to agree on the act that caused his death. The testimony of the medical examiners give you 2 different ways. The abdominal injuries that Alexavier had were a substantial condition resulting in his death. That's what Dr. Quinton testified to. He listed as the #1 cause on his report. Impairment of his physical condition by administering a drug is another way of committing child abuse. It's an intentional act, it impairs his physical condition, and the administration of Xanax caused his death. Either one of those, as long as all 12 agree, is sufficient for finding and answering that question, yes. Dr. Endres said in her testimony that this defendant avoids responsibility, that this defendant projects blame on other people. You witnessed that through the defense testimony over 2 days. There was something that the defendant said twice during her testimony that all of you should agree with. This defendant told you twice that Alex was murdered. Alex was murdered. Alex was murdered by this defendant. This defendant does everything she can to avoid personal responsibility. Give her a lesson in personal responsibility and find her guilty.
You just like getting beat. Ladies and gentlemen, is there a more terrifying thing a father could say to a 6-year-old child? A child who depends on him for protection? A child who cannot defend himself? And so he naturally looks to his father and should be able to expect that he won't harm him. Pedrin's statement tells you something. Do you like getting beaten? Tells you that it happened before. It tells you it was going to happen again. Tragically, it was routine. And it tells you something else that is critically important in this case. It tells you that Derek Pedrin was not Alexavier's protector. He was his abuser. And that matters. That matters because this case is not just about what happened to Alexavier. It is about what law enforcement chose not to see. It is about what they refused to investigate. It is about how they locked on to Josie Dikeman from the very first hour and never honestly revisited their assumptions, even after the medical science, the facts, and their own forensic pathologist proved that major parts of their theory were wrong. From the very beginning of this case, back in 2023, the government has tried to give us all a headline. Mother murders stepson and stages scene. That is the government's headline. It is dramatic. It is sensational. It is horrific. And it triggers a powerful emotional response. It is exactly the type of accusation that can hit hard and cause people to stop thinking critically. But our law asks more of you than simply reacting to a headline. You must read the article. You must critically examine the evidence and separate emotion from proof and search for the truth. And when you do that, you'll see that the government has tried to give us all the wrong headline. What the headline should be is innocent woman charged, suspect at large. Ladies and gentlemen, this is a case about how innocent people get convicted of murder. And I want to put something right out in the open, just to say it. Usually when I go to sleep at night and hit the pillow, I'm out. I'm out for the night. But last night I didn't sleep at all. Because I'm terrified. I'm terrified that something I failed to do or say or failed to explain will end up with an innocent woman being convicted. And so all I ask of you is that when I inevitably fall short in giving you my thoughts on this case, that when you go back into the jury room, you draw upon your collective wisdom and the many, many notes you took throughout this trial. Now, this case comes down to three fundamental truths. The first truth is that this investigation was not a search for the truth. It was a defense of a premature conclusion. The second fundamental truth is that the medical science does not support murder. And the third fundamental truth about this case is that there are multiple reasonable explanations that are consistent with Josie's innocence. Overdose, Derek as the abuser, injuries not intended to cause death. And the list goes on. I would like to talk to you about some of those as we go forward. But I first would like to start where the law begins, the burden of proof. Proof beyond a reasonable doubt. And we've all heard that before. And what is the burden of proof? Well, the burden of proof was built on a hard lesson, which is that when the burden is too low, innocent people do get convicted. Because human beings, the courts are run by human beings. We are all human. We are fallible. We make mistakes. We make assumptions. We have biases. And the burden of proof is designed to protect against those very human errors. And that is why we have such a high burden. Because society concluded that it is unacceptable to convict innocent people for something they didn't do. So I'll talk briefly about what reasonable doubt is. But I'll first start with what it is not. What reasonable doubt is not, it's not that you think something probably happened. It is not enough that there is more evidence that you believe of guilt than there is of innocence. It is not even enough that you are firmly convinced, that you have a strong belief that something bad happened based on the evidence. That is not enough. The government must eliminate each and every reasonable hypothesis consistent with innocence, any reasonable explanation consistent with Josie's innocence. And we heard some of that in the trial testimony. We heard from Dr. Quinton that overdose is a very real possibility. It is squarely supported by the evidence. And if this was an accidental overdose, count one must fail. This is not an intentional homicide. And if it's an overdose, count three must fail. And that's just one example. And you'll hear more as we go forward. But it is important to know that you do not have to solve every mystery. You do not have to pick the explanation that you think is the most convincing. All you have to do is determine if there is one single reasonable doubt in this case. Just one. Now let's talk about the first truth in this case, that this case was not a search for the truth. It was focused on defending a conclusion from day one. A 911 call comes in, reporting the tragic death of a child. And even in that first moment, Josie raises the possibility of overdose. And so what do law enforcement do? By sheer happenstance, they arrive within minutes. And they immediately judge Josie guilty. Immediately, they conclude that she must have staged that scene. Immediately, they thought she must be covering for a horrible crime. Only a murderer would stage the scene. And what was their evidence at that point? Pill bottles around on the floor. They had no testing on those items. They formed a conclusion based on an assumption from day one and began defending that conclusion rather than trying to find out what actually happened. Now, let's talk about the investigation and the incredible failures that we saw because of a breakdown in the chain of command. Now, you saw from the testimony that there was no single person in charge of this investigation. And Lieutenant Williams, he agreed, this is not just an issue about flow charts and organizational dynamics. This is a critically important factor in any investigation this complex. There are hundreds of witnesses to interview, multiple competing inferences and explanations, medical science, forensic analysis, thousands of hours of video and audio and paper, hundreds of thousands of documents in this very case alone. And so it is critically important that you have one person in charge to assign tasks and to ensure that things do not fall through the cracks, important things. But that is not what we had here. There was testimony again that no one was truly in charge. And even Sergeant Amundsen, when he testified very reluctantly that he was in the lead. He was the last man standing. Now, there's an analogy that I think captures the concerns with this investigation. Imagine putting together a puzzle while throwing away every piece that doesn't immediately fit. You probably wouldn't end up with a complete picture. Now, let's talk about the behavior, the actions of what happened. Because an investigation should not just draw a conclusion and defend that conclusion. An investigation should actively try to disprove its own conclusion, just like the scientific method, to test all of the other possible reasons or possible explanations of what happened. But we did not see that in this investigation, and so we cannot be certain of its results. And a very early example of that, an investigation at the very beginning, it should expand. It should look at all the possibilities. It should not immediately narrow, but we saw how this investigation immediately narrowed when instead it should have broadened. And we see that in the DNA evidence, which you didn't hear anything about in the closing argument of the government's attorney. And why is that? Because the investigation into the DNA evidence and who touched the pill bottle and the cap was not designed to search for the truth. It was designed to prove that Josie had lied about staging the scene. How do we know that? Because they sent it in, but they only tested for Alexavier's DNA. And guess what? It was on there. That supports the idea that he got into something overnight. It doesn't support the staging theory. And so what did they do? Did they say, you know, that's unexpected. We should look into this. No, they immediately stopped and asked no more questions. They didn't test samples from the other adults that could have contributed to those items. They didn't test Derek Pedrin or Josie Dikeman or Karsten Jar. They simply said, oh no, this doesn't support our theory, so we're going to stop looking. That is the very first investigative decision that happened in this case. Even though the crime lab analyst specifically said, please send us more samples from individuals believed to be involved. They did not do that. Folks, this only required mailing in a DNA sample. And they didn't do that. If this were truly a search for the truth, why would they not submit comparison samples? Why would they not want to know who touched those bottles? Because what we were left with was uncertainty. And that uncertainty belongs to the government that has the burden. And investigators never tested the Coach bag. And think about that. What would that tell us? If Alex's DNA on the Coach bag was on the Coach bag, that would show that perhaps, that would show that he gotten into something. But they didn't do that. And so we don't know. We are left with incomplete evidence that we cannot rely upon. And there were pill fragments on the pillow that were never tested. And Dr. Quinton acknowledged this would be important contextual information, as well as Dr. Christensen, that would help us understand, was this an accidental overdose? They never tested. So here we have the centerpiece of the state's case, the state's homicide case against Josie Dikeman, and they never even fully tested it. Why is that? They want us to believe them. They say, believe us. We believe it, so you should too. But they don't have any facts to prove that because they didn't look for them, because they were afraid that the answer would not point to Josie's guilt. Again, they were not testing for their own theory being wrong. They were not truly searching for the truth. Contradictory evidence was ignored. And confirmation bias took hold of the investigation. And just briefly on confirmation bias, we all know what that is, even if we don't always call it that. It is what happens when everyone watches the same play in sports, and the Packers fans say, obvious pass interference, and the Vikings fans say, no, that was clean. And it's particularly powerful, for instance, in politics, when we seek out information and then have algorithms just feeding us back what we want to hear. And so we start filtering all of the evidence that comes in to be consistent with what we already believe. And to be clear, this is not about bad intentions or makes you a bad person. This is a universal human trait that we all have, and that is so powerful, not because it is overt or obvious, it is so powerful because it is subconscious. But it is powerful nonetheless, and that is impossible for any of us to deny. And police are not immune. Medical personnel are not immune. Children are not immune. We all seek to conform evidence to our existing beliefs. And it takes a lot of effort to avoid that pitfall. So again, let's talk about the tunnel vision on Josie. Investigators admitted Derek Pedrin was a suspect. Sergeant Amundsen said he is still a suspect to this day. That is the very definition of reasonable doubt. And there's more. 10 days into the investigation, investigators were already working with Derek Pedrin to defense-proof the case. Now, you heard Sergeant Amundsen come in and testify under oath. The first time that conversation happened, that was in September after Josie was already charged and arrested. Matter of fact, that's not true. It was 10 days after Alexavier had died. And I think that demonstrates one of the fundamental failures of this investigation, which is that none of the investigators had read all the reports. And the reason why Sergeant Amundsen didn't really know what happened in that meeting in September, which was a meeting that was never disclosed to the defense, no report was made of it. We only learned of it because we physically laid eyes on every bit of video evidence that was in this case, and we discovered this. And we said, Okay, here's a meeting with a key witness in the case, talking about problems in the case, talking about how the Xanax issue, and talking about Derek's phone. In the very beginning of that meeting, the investigators asked Derek, this was in September, "Do you still have that phone that we were interested in looking into?" He said yes. But then, a little while later in that same conversation, they asked him again, "Can we see your phone?" He said, "Phone? What are you talking about? It's broken. I don't have that phone." And they never even asked what he meant by that, not once. They never seized Derek Pedrin's phone at all, this entire investigation. And let's draw the contrast between that behavior and that of Josie's. You saw Josie's interview with Lieutenant Williams at the very beginning of this case when this had just happened. And Josie handed over the phone willingly. Now, of course, it is true that investigators could have seized that phone without question. And maybe Josie knew that. Maybe not. But what they couldn't have done is compel her passcode. And Josie gave them her passcode without any problem. And that unlocked her life for investigators to inspect. Guess who didn't do that? Derek Pedrin. And think about phones, just for a moment. A phone is no longer this rotary dial, object that we had in our house to communicate people across long distances. No, it is now essentially an alter ego. There is no single belonging that any of us possess that gives more insight into what we are doing with our lives, where we physically are located at any given time, what we're searching for, who we're communicating with, what we are communicating about. This gives police a roadmap into Josie's life. And because she had nothing to hide, she gave it to them. Can we conclude the same thing about Derek Pedrin? That is up to you to decide. So again, we see the investigation immediately focusing only on Josie and not testing its own theories. Now, again, Derek Pedrin admitted to Xanax bringing it into the house. But that wasn't what he said at first. He had to be caught lying in that very first instance. Because he first said that it came from Josie. It came from Josie's mom. It came from her prescription. And that was not true. And then he said it was from Ted Colkine. She got it from Ted Colkine. Investigators ran down that lead. Turns out that wasn't true. So finally, he admitted to being the source of this substance that we know could very well have killed Alexavier. But they never fully investigated. They never investigated his supplier. They never investigated drug transactions, and they never followed up on any of this evidence. There was a critical text about scripts on February 9 of 2023, one day before the evening into Alexavier's last day. And they never investigated that. We only found out about what was going on when Mr. Pedrin was up on the stand and Attorney Zacher asked him about it. That was the first time. Investigators apparently never asked. So we had to do that in open court in front of everyone and find out what the answer is. Let's talk about Derek Pedrin again for a moment. Investigators knew he had a lengthy history of violence, 7 criminal convictions, a serial strangler of women, Josie being first and foremost. Threats to kill Josie. He put her head through the wall several times. There were no contact provisions, but that was just a sheet of paper. And we also saw that there is evidence of child abuse. You saw that video. It was heart-wrenching. Do you like getting your ass beat? That represents rage, intimidation, and violence, and abuse. And when Mr. Pedrin was asked about that particular incident, the question was, you were out of control, right? You would agree. You were out of control. His answer? I wasn't out of control. I was just angry. Does that match up? If any of us were walking down the street and saw somebody behaving that way towards a child, would we say, no need to worry. He's not out of control. He's just angry. Well, apparently Sergeant Amundsen agreed with that as he testified. Now, there's another thing. And here is a very telling exchange. when Mr. Pedrin was asked, have you ever punched or kicked the children? His answer, I don't think so. Is there a parent in this world who cannot simply answer that question with a no? That would be a parent who has done that more times than he is willing to admit. And so we have repeated lies from a suspect in this own investigation, lied about the Xanax, and let's just ask if he's willing, and he lied about his alcohol use. Even though he got arrested months earlier from his testimony while he was intoxicated. I guess we have to believe that he forgot about that, but the truth is much likely different. And so if Mr. Pedrin is willing to lie about some of these the smallest things that don't matter in a criminal trial, are we really to believe that he wouldn't be willing to lie about what's most important to him? His own responsibility for Alexavier's death? That is a question that you will have to resolve. But the importance of this, the point is that the government's investigation, it created the uncertainty in this case. And they own that uncertainty. They created it, and they took on the highest burden in the law when they filed these charges. And they don't just get to come in here and throw out different possibilities of what might have happened. They have to provide precise proof of what happened in that house and what caused Alexavier's death. And so again, we saw no single investigator reviewing any of the case file, key interviews without police reports, and again, I must say one more thing about this meeting that happened in September that was not disclosed in any report. In a search for the truth, investigators document important witness context when they're talking about problems in the case. They're talking about issues in the case. They write reports. I mean, they wrote a report about some random person who evidently didn't know Josie and said something about how she wouldn't let her look after her dog. But they didn't write a report with one of their key witnesses, who apparently is still a suspect. Why? Because if you're searching for the truth, you document these contacts. But if you're defending a conclusion, inconvenient facts have a way of leaving no paper trail. So we see how evidence portraying Derek negatively was minimized or ignored. Evidence portraying Josie negatively was amplified and emphasized. Investigators never failed to follow up on statements that Derek treated Alex poorly. And these irrelevant comments were included. And we'll get to this later, but there was also a key piece of evidence in this trial that you heard, which was the 911 call in November of 2022, when Derek Pedrin had viciously assaulted Josie by repeatedly punching her in the throat and strangling her because she cooked the beef, the ground beef for the kids. That was his ground beef. And so that's what he does when you cook his ground beef for the kids. And she told you that in the 911 call, that she had no reason to know would show up in a homicide trial 4 years later. But what does that tell you? It tells you that she said he did the same thing to his 6-year-old, to Alex, and that he was teaching Alex to lie. That was in that call. That is a snapshot of what is actually happening in real time, before anybody knew it would become relevant in this trial. That is evidence you don't have to ignore. So let's move forward to some of the most dramatic, incredible testimony I've seen in a trial. When Lieutenant Williams was asked about what is the state's theory? Why would Josie do this? When she was looking forward to a date, she was taking selfies with Brantley, she was texting with Raphael, she was seemingly looking forward to a future with someone other than Derek. Why would she do that? And Lieutenant Williams' answer was, if you're saying she killed him that night, I have no idea. Once again, that is the very definition of reasonable doubt. If he doesn't know, how can we? And then you also heard from Sergeant Amundsen, the lead investigator, who apparently hasn't read all the reports, looked at the transcripts, or watched all the videos. He testified that that conversation about thinking like defense lawyers happened in September. That was wrong. It happened February 21. And he testified as well. What is your theory? Why would you do this? How did this happen? And he said the working theory is that Josie must have murdered Alex because he wouldn't let her go to sleep. She wanted to go on a date the next day, so she murdered a child. And that's their working theory. Like my working drafts, which go through 8 different versions before I finalize them. So maybe if we have a trial in 2 weeks, the working theory would change once again. Because they do not know. They are required, beyond a reasonable doubt, to prove exactly what happened, not to provide us with a working theory. So if the supposed lead investigators can't explain to us what happened, how can we know? And why don't they know? It's because the evidence in this case never supported the murder theory. The evidence kept pointing back towards overdose, towards Derek, towards uncertainty. But that overdose evidence was ignored. You heard from Dr. Quinn. He could not determine the exact cause of death, and he could not rule out overdose. And he said that Xanax's role in this was crucial. What does that mean? That means that overdose is not some far-fetched speculative theory. It is reasonable. It is medically supported. It is consistent with the toxicology. And it is so critically important to understand that if this was an overdose, intentional homicide is not proven. Count 1 is not proven. Count 3 is not proven. And that is enough for reasonable doubt just in and of itself. But then we have an example from the medical examiner, from Ms. Lubinsky, who, I guess in Wisconsin, well, I know in Wisconsin, we don't have medical doctors who serve as medical examiners. I guess that's unique to us. But it seemed like Ms. Lubinsky was much more of a police officer than a medical professional, because her entry into the case essentially was an attempt to overrule the pathologist who said that this was homicide due to the actions of some other person. But instead, she wrote that there was homicidal violence and that Alexavier died from homicidal assault. Those were her words, not Dr. Quinton. He told you that. Those weren't his words. He wouldn't have used them. And so what does that tell us? Well, what it tells us, as well as Ms. Lubinsky's testimony, about how the mindset had taken such strong hold that this was only about proving Josie guilty. It was not about exploring what happened. And that is why Ms. Lubinsky came in and she told us all that there were brown bananas on the fruit stand in their house. And we saw the photo. The brown bananas were next to fresh fruit and other snacks that the kids could get freely. And frankly, if brown bananas are criminal neglect, then you're going to have to lock me up too, because how many of us have not let bananas overripen in our kitchen? But the point is that bananas are not evidence of criminal neglect. They are evidence of how confirmation bias was so powerful in this investigation. And look, we know why that was. We know why. It was because Josie was never going to be able to move past her earlier convictions in 2001 and 2011 and 2013. And I will say, my biggest fear in this case is that you will not be able to look past this evidence for what it is. It is the state attempting to distract you, to overwhelm you, to provoke anger, to distract you from anything but the lack of evidence in this case. We never tried to hide this from you. We told you this was coming. But if the state had the facts to prove its case, they wouldn't have to rely on convictions that go back to up to 15 years ago. And the state is trying, not subtly, to use this prior conviction as evidence of current guilt. They're trying to say she was an abuser then and she's an abuser now. That is what they're trying to get you to conclude. But the evidence doesn't support that. The 2011 evidence did not conclude that she was abusive. This was an incident where a young child fell down the stairs. And this similarity, I think, explains why they believe that they can use that to say that she must have done something wrong here. But the facts are much different. In that case, Josie was a 19-year-old addict, and she did not care about her responsibility. She was neglectful, and a child was injured falling down the stairs at her apartment. Now, that was investigated at the time. And investigator Tony DeLapp, the officer who investigated this, walked through the house and noted no inconsistent information about what she had reported. Josie took the child immediately into the hospital. And there was no medical certainty in that case. 4 doctors agreed that this was consistent with the explanation. And there was not one doctor who was willing to say that this was abuse. And there's another important aspect of that. There was evidence that was destroyed as part of that. And the instruction says that you can conclude, you can draw the inference that this would have been favorable. But the point is that abuse was not established at all in that case. And there was no conviction. But there was another concerning circumstance with Haley in 2013. To be sure, there were some fractures, and there were some other conditions having to do with malnutrition, vitamin D deficiencies, other physical ailments that are dangerous for a child if they're not treated. And that was investigated thoroughly. And it was believed that as to the physiological conditions, that she had celiac. And celiac basically explained all of these conditions. It's basically a disorder that prevents absorbing proper nutrients. And that explains vitamin D deficiency. That explains some of the other findings. This was a coherent explanation from the medical science of what would lead to some of these conditions. But then you did have these concerning injuries. But what did they find out? They investigated everybody in that household. They interviewed them. Not one of them said that Josie was abusive towards the child. Not one. In fact, her partner at the time, who was the other caregiver who was in that household all the time, he had no job. Josie didn't work full time, but she was picking up shifts when she could. But her partner, Dustin Barnes, told investigators she never hurt the children. That was what's called a statement against interest, because he was the only potential source of those injuries. And once again, there was no established abuse by Josie in that case. The conviction was for neglect, not abuse, and that is important. Now again, the government wants you to conclude that Josie was an abuser then. She was secretly an abuser, and now she's an abuser now. But you cannot use that reasoning. The instruction tells you that you cannot use that evidence to say that this is what happened. And again, if they had the facts to support their case, they wouldn't have to go lean so heavily on an older situation that doesn't even prove what they say it does. And just one quick point on that, which is that most people don't know what actually happens in criminal cases. All people usually know is what is in the criminal complaint. And that is a document written by prosecutors that has all the bad information that makes you look guilty, makes you look the worst. But people don't have access to the police reports. They don't have access to the medical experts, any of the forensic analysis. They don't really know the facts. And so when somebody has a past, particularly in a very troubling case, people are inclined to believe the worst because they just don't know the details.
Judge, I'm going to object. We stipulated to these facts, and we're now arguing the facts that we stipulated to?
I assume he's talking about the stipulated facts.
Yes.
Can
I'll
talk
move on.
about the
I'll
stipulated
move on.
facts.
So again, this is evidence meant to insinuate that Josie is secretly abuser without evidence. And there's a saying that where there's smoke, there's fire. And that is true. As far as I know, I don't know anything that produces smoke other than fire. But what looks like smoke is not always smoke. And in this case, what you're seeing is the massive cloud of dust that they are kicking up to distract you, to overwhelm you, to inflame you, to do anything other than look at the evidence in this case, or lack thereof. Now, the neglect case was very serious. It was wrong, but it was not abuse. And it does not explain what happened in this case. But what it does explain is how the medical providers were so quick to conclude that Alexavier had been abused in the femur fracture incident. And I won't dwell too much on that because government's lawyer didn't talk about it too much. But just to be clear about that, the medical expert who looked at this femur fracture, who was most qualified to make an opinion about it, He said that this was 100% not abuse. Doctors don't speak in such certain terms unless they know something is true. And that was true. And Dr. Peterson knew that. And that was why he was so certain. And these other concerning conditions that I think the nurse was reasonably concerned about, and Dr. Glowacki, who you heard from, reasonably concerned about, those were found out to be not fractures, those were developmental conditions. But they look like fractures on an x-ray. And so the providers were concerned, reasonably. But the facts turned out not to support their concerns. And again, the only qualified expert that we heard from says that that was not abuse. And it is reasonable to believe him. But we saw through that femur fracture incident how suspicion immediately became conclusions. And that is the problem in cases like this, because we're talking about very difficult subjects, and it's hard not to get very angry about this. But anger clouds our judgment, and it clouds our ability to critically examine the evidence. And that's what we're here to do. So, touching once more on the second point, which is that the medical science does not prove murder in this case. In fact, it suggests otherwise. Overdose as a possible cause of death. Injuries that were not inevitably going to cause death. Injuries that do not reflect an intent to kill. That's all testimony that you heard from the medical experts. You heard that there was no fatal head trauma, no strangulation, and the blood loss was not a fatal amount. And you heard that alprazolam was crucial to the finding of the cause of death. None of the experts qualified could conclude that there was an intent for Alexavier to die. There was toxicology, again, showing highly elevated levels of alprazolam. This is not disputed. That was enough to kill an adult and certainly enough to cause a child's death. But here's the other point that's very important, is that this was a gradual process. And that reflects not a sudden, violent, homicidal rage. That is a gradual process, and sadly, it's consistent with overdose in this case. And the blood loss numbers, again, not sufficient to cause death. Those were not injuries that were inevitably going to lead to death. You had effectively 1/15 of the total amount of blood volume lost when you have to reach approximately 33% to start going into shock. And so these were awful, but they were not the types of injuries that would inevitably lead to someone dying. So again, the medical science contradicts the state's murder theory, and it points toward overdose. So I'll move on to a very important issue in this case before getting to the elements, which is the witnesses that you heard from and determining their credibility. You have Derek, Loralee, Major, Brantley, and children's statements filtered through adults. And you heard the statement, do you like getting your ass beat, whether you punched or kicked the children? I don't think so. Derek testified that he couldn't control his violence. So let's talk about Derek Pedrin's credibility. We've heard about all of the violence. Indisputably, he was deceptive throughout the investigation. He was shown to be manipulative, chronic liar, an alcoholic addict. And there was this sham marriage with Loralee, which we heard about from Misty Craig. And he lied about the timeline. We'll get to that. The timeline of when he got home that night, the night before Alexavier died. But let's just take some basic impressions from that testimony, because there were so many lies, it was very difficult to categorize and catalog them. But here's a figure that I think tells you all you need to know. When he was asked questions on his direct, questions that were designed to make Josie look bad, he was very certain. He was certain of his answers. When asked questions that would have made Josie look good in any way, he testified, I don't recall, 130 times or more. If you're telling the truth, you do not have to remember what you told other people. And you experience this, having to go in and out while Pedrin had to constantly be reminded of what he had said on a video recording or an audio recording or something else, just to remind him, yes, that's what you said. You remember that? Again, if you tell the truth, you don't have to remember what you said. And then we had Misty Craig, who testified very reluctantly. I don't know about you, but she looked like another victim of Derek Pedrin. Well, in fact, she testified that she was, because this was the Derek Pedrin who was the abusive thug staring at her from the gallery. And she testified reluctantly, but she acknowledged that Derek said that he would cut her head off and send it to her mother if she testified about the trial. And he said that he cut by telling her about the marriage to Laura Lee being related to this very trial. And then we had Justin Bolito. Thank God for Justin Bolito, the Good Samaritan that was watching this trial on TV like many others are. And he was so astounded and outraged by Pedrin's lies, open lies on the stand, that he reached out to us to set the record straight. He did not want to get involved in this. That is the last thing he wanted to get involved. But he was so troubled by the lies about Derek claiming he never used Xanax that he put himself into this, understanding that he could be put through the ringer. And boy, that is true. You saw the government's lawyer go up and just trash him and berate him with accusations that, let's put it this way, must have come from Pedrin without verification. That's all I'll say about that. But what the government lawyer didn't attack was Justin's testimony about Derek Pedrin using Xanax. Never attacked the veracity of that. Apparently, according to the prosecution, this young man was engaged in some big grudge against Pedrin for terminating his employment at the car wash in some sort of epic bid to regain his minimum wage employment at ShipShape. Is that realistically something that people would want to do, to insert themselves into a trial like this because they want to get their job back to work under Derek Pedrin? There's a law school saying that if you don't have the facts, you pound the law. And if you don't have the law, you pound the facts. And if you don't have either, you pound the table. We saw a lot of table pounding in this trial, did we not? Now again, if Derek Pedrin is willing to lie about these things, what makes us think that he wouldn't lie about his responsibility for Alexavier's death? You have to rule out beyond a reasonable doubt that Pedrin was the source of the Xanax. He admitted it. You have to rule out that Pedrin was the source of the injuries we know that they could have occurred at the time when Derek was alone with Alexavier. We know that. And we know that Derek lied on the stand. Now, a reasonable doubt is a doubt that would cause you to pause or to hesitate when called upon to act in the most important affairs of life. And so what are the most important affairs of life that we all go through at some point? Whether to choose a partner, where to live, educational decisions, financial decisions, medical decisions, buying a house. Well, forget buying a house. Would anyone buy a used car from Derek Pedrin? And how about Brantley and Major? Their testimony fell well below reasonable doubt. But the government is not trying to sell us all a used car, sell you a used car. They're trying to sell you someone's freedom. That is why this is so serious and important, that this is taken, that is analyzed carefully, cautiously. So let's talk about the children's testimony. There's not a question about whether those children are sympathetic. Of course they are. But the question is reliability. The question is whether we can rely on their testimony in a trial for first-degree intentional homicide. The state must prove beyond a reasonable doubt that these children weren't coached. The state must also prove beyond a reasonable doubt that they did not lie under oath repeatedly. And they also must prove beyond a reasonable doubt that these children were so consistent, so credible, that their testimony can be relied on in this very homicide trial. What did we hear from the children? Again, the same habit of answering certain questions with with confidence that made Josie look bad, but anything that made her look good in any way was met with a, I don't know. Now, this is something that I don't know if everyone caught when Brantley was testifying. Well, she was calling Josie, Mom Josie a lot. That was the name that he used instead of Mom. He said, Josie did this, Josie did that. But at one point, he answered, our mom. And then he immediately corrected himself. He corrected his own testimony and said, Josie. Now ask yourselves, does that sound natural, or is that something he was taught to say? And he apologized. He apologized to Pedrin in the middle of his testimony, and he was asked about that when he came back onto the stand. And he said he apologized to his dad for lying. So he admitted he lied on the stand. But what did he say that he apologized to his dad about? He apologized to his dad for not telling the jury, for not telling you that his dad was an alcoholic, basically, that he used alcohol. That was what he said. I'm sorry, Dad, I didn't tell him that you used alcohol. Now ask yourself, does that make sense? Do you think that he was apologizing for making his dad look good in the eyes of the jury? Or is it that he let slip something he was told not to say? When you have competing inferences and competing doubts, the jury instruction tells you very clearly that you must resolve every reasonable doubt in favor of Josie. And that is the rule that you will need to apply when you're in the jury room. And again, bringing it back to that 2022 911 call, where Josie reported this assault from Pedrin regarding the ground beef. And she said, Derek repeatedly punched her in the throat and strangled her, and that he did the same thing to Alex, and that he was teaching his son to lie. That is as reliable as you can get. That occurred at the time, not in preparation for this trial. And that's important, and you can consider that. And so let's talk about Brantley's testimony about the femur injury or the supposed kick down the stairs. So he says, apparently he was not talking about what caused the fracture, that this happened after Alexavier had broken his leg. And you must ask, is that consistent at all with the evidence? Now, there was no certainty of the exact day, and we can't rely on his dates, but let's just look at the evidence that we have, the objective evidence about that injury. There was a follow-up appointment with Gunderson, where he was found to be healing well. Dr. Glowacki checked in, make sure that happened, and Josie took him to the follow-up appointment, and he was doing well. And then Sarah Wagner-Barton, the CPS worker, she did a home visit. She came through the house. Now, first she talked to the medical staff, and the medical staff had no concerns about Josie. And she also found that the kids were in good spirits and that she found no immediate safety concerns. But there was another little detail in that report of her talking with Alex and the family at Gunderson, where she said that Alex did tell her that Dad would spank. Well, and moving on, Ms. Wagner-Barton then went to do the site visit at the house, and she went through and she saw that the kids were being well cared for. They had all of their basic needs met. She had no concerns. Alex was doing well. He was proud of his cast. He was healing well. And that tells you that he was still healing well. He had not re-injured his femur. And then we do have the autopsy report. And there was no evidence that his femur injury had been aggravated. So the objective evidence contradicts this idea that Josie kicked this child down the staircase, and we saw that staircase. That thing was a death trap. And just to reiterate, the staircase condition was dangerous, but Josie was a renter. Shame on that landlord for allowing them to live in that condition. A tenant cannot be expected to just install railings or put walls alongside a staircase, finish a basement. That is not within their capacity. And so that is something that cannot be held against Josie. Now let's talk about Major Hellerud, in his testimony. And the issue there is that you saw his testimony evolved as contrary facts got in the way. Reliable memories do not shift every time they are tested. And again, if you're telling the truth, you don't have to remember what happened. So you had the changing bedroom account, where Major's story changed as the facts developed. First, he saw this attack supposedly in Josie's bedroom through from his bedroom into hers. But then he was confronted with the fact that there was a curtain up. And so he said the curtain wasn't always there, or it wasn't always up. And then when he testified at trial, it became he actually walked into the room. How can we know? None of those all cannot be true. And you can disregard that testimony because you have to determine whether it is precise proof that you can rely upon. And then you had this implausible testimony where Major said that Alex soiled himself because his mom would have let him go to the bathroom. Now, does that make sense that Josie would make a child soil himself so that she would just then have to clean up herself? That makes no sense. And then you saw the delayed appearance of this other serious allegation about the bending of the leg back while choking, which is how he mimicked it in the interview. And this was not mentioned in the first interview, but it appeared only after he had discussions with family and reappeared. But then he testified at trial to the opposite facts, that somehow this was a bending backwards. And this was a completely implausible mechanism for injury. So this was implausible, and it changed over time. And we all know that we show that the evidence suggests that the family discussed the case with Major. And there were concerns about coaching. And so the pattern was, Major remembered dramatic accusations, but when he was confronted with inconsistencies and prior statements and specifics, his response became, I don't remember. Again, how many times did he not remember? 137 times. He remembered the accusations, but not the contradictions. And the law requires testimony that is so consistent, so credible, that no innocent explanation could be true. So, does that mean you should not rely on anything the children say? Well, think about the example of a big pot of stew that you're making for the family. And somehow a big piece of rotten meat goes into that stew. Would you still keep the stew? Would you eat it? Or would you throw it away and start again? That is why you cannot rely on these statements as precise proof of the allegations in this case. We know the state itself is uncertain. We heard that from the lead investigators. But we also know because of the charges in this case. We see how the government added charges in the very middle of the case. That's why you have a new option here for reckless homicide. Because the state is trying to throw everything that they can against the wall and see what is going to stick. They need something to stick. But let's talk about the first count, intentional homicide. The state must have precise proof of causation. And if overdose is an explanation, there is no causation. And if injury is insufficient to cause death, that is not causation. So what do we not have here? We have no motive, we have no eyewitness, and there's no DNA tie, and there's medical uncertainty, and no coherent explanation. Why would Josie suddenly become a murderer while texting with Laura Lee and phone calls with Laura Lee and texts with Raphael, planning the date next morning with children? And let's talk about the timeline of that evening, the day before, February 10. Derek Pedrin arrived home at 5:30. How do we know that? Not because he told us. He said he got home at 6:30. But then we found out because we had the surveillance evidence to prove that he had left the Walmart at 5:30. And why would he lie about when he arrived at the house? He thought he would get away with misleading you. And we wouldn't have found out if we hadn't looked at the footage. Perhaps the government hadn't looked at the footage. But if he's lying about the timeline, then we have to wonder, is he lying because he thinks he'll never face accountability? And we know that Alex was awake at the time Derek was around. This was something that Major certainly testified to as well. But let's just get to one detail that I think is very important here. Pedrin testified that he had changed Alexavier's pants. But there would be no...
That mischaracterizes the testimony. Mr. Pedrin never testified that he changed. That came from the defendant.
Forgive me. There was testimony to that effect. Thank you. But there would be no reason to do that if he hadn't soiled himself. So again, we know that Alexavier was up at some point, and we know that he was asleep during the welfare check. And we know from the medical experts that that would be consistent with either potentially a concussion, mild concussion, or mild alprazolam intoxication. And so that is certainly consistent with the timeline. And we know that Pedrin was downstairs near him at that time, and that Derek had Xanax access. And so we know that Josie was texting about going on a date, and she slept from 3 to 9. Is that consistent with someone who knew she had just murdered a child? And again, her behavior in the morning, it was normal. Normal texts, ordinary plans. And then a shocking discovery and CPR attempts. Immediately raising overdose as a concern. Panic. And is this consistent with somebody who had just brutally murdered a child? Now, I remember we watched the interview with Josie with Lieutenant Williams. We all watched that together in the trial. And I remember watching that for the first time. And what I saw was a woman who was in shock. She was self-soothing. She appeared to be in disbelief and in grief. And it felt real to me on a physical level. This did not seem like a woman who expected for this to happen. She did not look like a woman who had just murdered a child. And so the reality of the home was that Derek dominated that environment with fear, intimidation, violence, drug use, children cowering in closets. And we have evidence of Josie's relationship with Alexavier. She communicated with the school regularly. She wanted to make sure that he was able to celebrate his birthday because he had a summer birthday, and didn't want him to feel left out from the other kids who could celebrate their birthdays. She wrote to the teacher to make sure that Alexavier, she was concerned he was getting bullied. And so she wanted to make sure that Alexavier is not being bullied. Is that a woman who had callous disregard for this child's safety? Is that something, if you had just this murderous rage for this child, that you would do something like that? She wanted to make sure that his winter gloves fit properly, that he had water, that he had toys, that he had Happy Meals, having him sleep next to her in bed, taking him to doctor visits, making sure that he had badger care so that he could have dental care. When his dad had simply just tried to take a cap and shove it back into his mouth. And then we saw the Walmart video where Josie made sure that his sister went and got him a sucker. She wanted Alex to have a sucker too, so he didn't feel left out. She cared for Alex, like her own son. And again, does this seem like someone who had hidden homicidal rage for a child? This death was tragic, but it was not intentional. So, count 2, we see a contradictory theory where either she intentionally or recklessly killed him, but if you don't believe that, then she negligently caused his death. And you must find 3 separate acts of criminal neglect. Not just careless or something that could have been done differently. Neglect, criminal neglect, and causation. And to prove causation on count 2, you have to believe the government has to prove beyond a reasonable doubt that Josie knew where Derek had put the Xanax in that household. Now, there is no proof that Josie knew there was still Xanax in that house. Derek was connected to the drugs, but there's no proof that she controlled the Xanax or even knew where it was. Now, Derek was an addict facing arrest. The simplest assumption or conclusion is that he either took it or flushed it. She would not know what he would have done with it while she was dealing with Sergeant Kernine. You cannot negligently fail to secure something you don't know is there. And if Derek caused the injuries were not obviously fatal to somebody who would observe Alexavier. There was no proof that Josie knew that his death was somehow imminent. Tragically, abuse had been normalized inside this home. Now, hindsight cannot replace proof. And this is an attempt to get the jury to reach a compromise verdict. And if you don't believe the other theories, then you can settle on this one. But the law doesn't permit compromise when the evidence does not support chronic criminal neglect. And so let's go to count 3, repeated abuse and abuse causing death, that Josie failed to prevent abuse or caused abuse. Now, the major failures of this count are that, again, overdose is not ruled out. Injuries not proven to be fatal. And Derek, as the source of those injuries, not ruled out. And in terms of the failure to prevent any of that, they have to show a capability to intervene or a capability of doing something that would have prevented future harm. Now, let's talk about the bathroom incident. Derek goes into the bathroom with Alexavier and closes the door and locks it. She thinks he heard Alexavier, but she doesn't know exactly what happened. What is she supposed to do? Kick down the door? Physically overpower this person who has abused her repeatedly? Or call police at that moment? Calling police has never worked before. Calling the police would not protect her or Alex because Derek would get out every single time and the beatings would only increase. And again, remember that 911 call where she did report Derek hurting Alex and teaching him to lie? What happened after that? He got out and he immediately battered her again. Calling the police would not have caused or prevented, or would not have prevented future harm. We know that restraining orders wouldn't stop him. Nothing would stop him. So, before I sit down, I want to share some final thoughts. Because when I sit down after this, the government's lawyer has the last word because the government has the burden of proof here. So I just want to say thank you for sitting through what has been a painful trial. We could not do this without you. But you are doing it, and you are doing it the right way. And this case is heartbreaking. A young child died under horrific circumstances. Alexavier should have had a future. He should have had an opportunity to become something other than his father. And sadly, that opportunity was taken from him. And if I were sitting where you're sitting right now, I would want to punish someone for what happened to Alexavier. I would want that. Anyone with a conscience would want that. But the person who deserves that punishment is not on trial today. And I ask you not to convict Josie for her abuser's crime. Because the law requires justice. And justice is not vengeance. Vengeance is easy. Vengeance says a terrible thing happened and somebody must pay for it, even if the proof is uncertain. Justice is much, much harder. Justice requires discipline. Justice requires understanding when there's no uncertainty, even when it's emotionally unsatisfying. Justice requires understanding that sometimes the evidence doesn't provide a neat, complete answer. But does it achieve justice to rely on an investigation that searched only for evidence of Josie's guilt? Does it achieve justice when the medical science does not support the government's murder theory or its allegations of count 3? And does it achieve justice when there remain multiple reasonable explanations that are consistent with Josie's innocence? It is up to you alone as jurors to determine that. Now, your duty is not to the defense, not to the prosecution, not to public opinion, emotion, or sympathy. Your duty is to the law and to your own conscience. And to be able to walk out of this courtroom without ever having to wonder whether you may have convicted an innocent person. And if you have that doubt, then you have your answer. Not guilty on all counts. Thank you.
Thank you.
Do you want me to go, Your Honor, or do you want me to?
Do we need a break for 5, 10 minutes, or do you want to go ahead? Like everybody's ready to go ahead? Why don't you go ahead?
Ladies and gentlemen, believe it or not, my favorite jury instruction is the burden of proof, because it says exactly what your job is. Your job is not to search for doubt. Your job is to search for the truth. What you just heard was the smoke show continue that Josie started, the defendant started with her testimony. Look at all of these other things, but how much of what the defense argued focused on the 2 days involving Alexavier's death? Heck, how many times did you hear the name Alex or Alexavier during their comments? They brought up the 2011 and 2013 other acts as if that was the entirety of what the state relied on. The state's argument regarding those was less than 5 minutes, and the state's argument regarding those told you exactly what the law says on how to use it. They're the ones that brought up using it improperly. I want to talk first about the accusation about the investigation in this case, and that there was tunnel vision associated with this defendant, because nothing could be further from the truth. The defense gave the example of a puzzle that is missing pieces. There was a puzzle with missing pieces in this case, but it was the defendant that was taking those pieces away from the. When they responded that day, they were first responders trying to save Alex's life. They performed CPR on Alex's body. In the efforts of trying to perform CPR on Alex's body, they moved the pill container. They put it on the bed. They touched it. When this case was first being investigated, as an overdose. That pill container was sent out to the crime lab to see if it had Alexavier's DNA on it. Why? Because law enforcement was looking to see if this was, in fact, an overdose, just like the defendant said. That's why they sent it out looking for Alexavier's DNA. They were investigating it as an overdose. If you looked at the first search warrants in this case, which was brought up, the first search warrants were looking at child neglect resulting in death because they were looking at it as a potential overdose where drug exposure happened in the home. Is that pointing the finger at this defendant? No, that's keeping an open mind. You heard that the defendant willingly gave over her cell phone. You saw the video. Investigator Williams said, we're going to get a search warrant for your phone. She knew they were going to get a warrant for her phone. It was with that information that she turned it over. But the defense paints it like it was a voluntary, here's my phone, here's my passcode, look at whatever you want. That's not what she did. And don't let them portray it that way to you. Law enforcement did investigator search warrants for her accounts, Google, Facebook. But they also did them for Mr. Pedrin. They were also examining him as a potential suspect. You heard that they did search warrants for her and for Mr. Pedrin. But it was this defendant's words to investigators originally, and this is important. That morning, she said that Alexavier was asleep the entire time that Mr. Pedrin was home. Alexavier was asleep the entire time that Mr. Pedrin was home. Why is that important at that stage of the investigation? Because the autopsy is done on February 13th, and that's where they see all the internal injuries. Based on the internal injuries, they now know that this is a child abuse case, that it's a severe child abuse case. But what the defense doesn't want you to know is that the investigators are relying on her word during this portion of the investigation. Her word is that Alexavier was asleep during that time frame when Mr. Pedrin was home. And so what does that mean? That narrows the suspects. Mr. Pedrin couldn't have committed the child abuse according to her words. And so they have now lost probable cause to get a search warrant for his phone. But they don't tell you that. And so they continue to investigate. They have the internal injuries. They have the forensic interviews of the children. And the forensic interviews of the children, in all of the forensic interviews, not one of the children ever says that Mr. Pedrin does any form of child abuse to any of them. Araya, no child abuse by Derek Pedrin. Brantley, no child abuse by Derek Pedrin. Major, no child abuse by Derek Pedrin. But they all point the finger at this defendant alone. Those children were in two separate homes, and they talk about hitting, kicking, and choking by this defendant. That's magnificent coaching by some power from above that children in different homes can magically say the same thing unless that's what happened. And so now, they are looking at this defendant for child abuse. Because this defendant's own children say she's a child abuser. And then they get the toxicology results. And they have a conversation with Mr. Pedrin. And I want you to think about what Mr. Pedrin says regarding the toxicology results. I buy Xanax. He's admitting that he illegally purchases Xanax. He's admitting that he illegally purchases Xanax for her. And who has the phone? The only phone with a text message that comes back to Xanax. This defendant. Text message to her mother saying, do you want to try a Xanax? What does that message tell you? She has Xanax, she possesses Xanax, and she's willing to give it out to someone else if they want to try it. Now, she's had the benefit of listening to everyone testify. She's had the benefit of seeing that text message and knowing it's going to come into evidence and having to come up with an excuse for it. And how much did you hear that she was prepared? She initially said that she prepped every week since being charged in this case for the moment that she was on the stand. Think about when she was charged with the offense and she got a copy of the criminal complaint. And it mentions the child abuse, and it mentions the Xanax for the first time. She knows about the results. Who's the first person she calls in this world? Mr. Pedrin. What does she say to him? I love you. Repeatedly. I love you. Do you love me? I want to talk to the children. And what does Mr. Pedrin say? He allows her to talk to the children. You heard arguments from the defense about the theory of the case. The theory of the case. Investigative Sergeant Rich Amundsen testified that Mr. Pedrin is still a suspect. What do you know about this case? You know he was bringing Xanax into the home. Heck yeah, he's still a suspect. You know he committed child neglect. Heck yeah, he's still a suspect. There's nothing that Investigative Sergeant Amundsen said that is not true. But they want you to believe that because he's a suspect in those things, he's a suspect in the abuse and death. That's not what was said. They were asked if he was still a suspect, and the answer is yes. To neglect, to delivering Xanax to her. And you're asked about a working theory of the case. You heard the theory of the case, not from Investigator Williams, who was removed from the case after doing a few months' work on it, is obviously upset about being removed from the case and hasn't done any work on it since, but you did hear a complete theory of the case from the investigator that's been on it ever since. Let's talk a little bit about the DNA evidence, because the defense wants to make a big deal about that DNA evidence, right? You didn't test the bag that belongs to this defendant. You didn't test the pill container that belongs to this defendant. It was tested. It was tested for Alexavier's DNA. And then when they went back and watched the body cam, they saw CPR being performed, and then they saw those containers being moved. That's Alexavier's DNA being transferred to those containers. The bag is her bag. Of course it's going to have her DNA on it. What they didn't explain, and what they can't explain, because it demonstrates her guilt beyond a reasonable doubt, is that bag coming down and being put on the floor, is that pill container being emptied out, is that pill container being used to stage an overdose. And what did that buy this defendant? It bought her time. It bought her time that day, because the investigators allegedly looked at the scene and said, this does look like an overdose. But then they started putting the pieces together. They started looking at the evidence, because what they didn't know when they responded to that scene was all the internal injuries that Alexavier had before he was administered those drugs. When you know those injuries and you know how severely this child was abused, when you know that in the context of this bag and a child having to open that container, and when you know that the pills were dumped in that bag, you know it's staged. The defense also keeps throwing out overdose, 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 as if that's what the medical examiners said in this case. The practice of medicine involves differential diagnosis. It involves looking at the entirety of the facts and the picture. If you look at just the pills and the toxicology results in this case, it's consistent with overdose. That was the question. But you have to look at it in the context of a beaten and battered child who is then drugged, who is then given the amount that could kill an adult human being. Who is given an amount that's going to result in that child being unconscious and dying within hours. That completely removes Mr. Pedrin. There's only one person in the world who had the ability to administer drugs to that child, this defendant. There's only one person who had the ability to abuse that child without anyone else knowing about it. That's this defendant. There were other children in the home. Mr. Pedrin was there. She said Mr. Pedrin couldn't have done it originally. It was only after being charged at trial that she says, this is what I heard in the bathroom. But you also know that didn't happen, because you know how severe those injuries are, and you know how symptomatic Alexavier would have been. A fractured rib, a lacerated liver, bleeding into his mesentery. You saw the photographs of all of his injuries. You heard that law enforcement had contact with him and saw none of that. You heard that Laura Lee heard a voice of a child that was okay at 10:30 at night. Dr. Quinton testified that both the injuries and the toxicology in his system were substantial factors to his death. So no, it's not correct that if you rule out toxicology as an overdose, and if you look at just the pill matters, that this isn't a homicide. That is not what Dr. Quinton said. And the other forensic pathologist, the one who didn't write a report, if we're going to criticize law enforcement for not writing a report during a meeting with somebody, what about their forensic pathologist who didn't write a report with all of his findings and conclusions? It was left to me asking questions, only to find out that his opinion is that an adult abused a child, that he would have been symptomatic rather quickly as a result of those injuries, and that with that amount of toxicology of Xanax in his system, he would have been unconscious and dying within a few hours. That was their expert's testimony that he couldn't bother to put in paper despite being paid $12,000. Why, the defense screams. The instructions that you have in front of you say that the state does not have to explain motive. And don't let them put that on the state. That is not the state's responsibility. The state's responsibility is to prove facts and evidence. And the facts and the evidence are that this defendant brutally beat a child and then administered Xanax. There's only one person in the world that could stage that scene, to bring that bag down, to empty the pill container, to put it by the body, to buy more time. Those who have nothing to fear have nothing to hide. Who's the person who's been hiding things and concealing things since the very beginning of this case? Whose testimony wasn't even commented on by the defense? This defendant. If children get something wrong on the stand, they're inconsistent. If children are too consistent, they can't be believed. That's also what was argued in this case. What kind of world do we live in where we can attack a child no matter what they say in a courtroom? It's just never going to be good enough. Because child abuse is a crime that happens behind closed doors, and if it's children that witness it, too bad, so sad. No matter what, they just can't be believed, even when they're that consistent. Those who have nothing to fear have nothing to hide. This defendant has hid a lot. Tell her that you see her. Tell her that you see her for who she is. Tell her that you know what she did to Alexavier. Tell her she's guilty.
Thank you, Mr. Torberson.